Hi, everyone. Welcome to today's webinar. My name is Nicole with the San Diego Law Library. I see that we have people joining, so I'll give everyone a minute to get signed on. I have here with me today Candace Moon, who will be discussing legal issues faced by craft breweries. I just have a couple of housekeeping things to do before we get started. First, you should have already received a handout for today's webinar. If you have not received the handout, please email refdesk@sdlawlibrary.org. Again, that's refdesk@sdlawlibrary.org. So refdesk@sdlawlibrary.org. And we'll resend the handout. Next, for those of you who are here for CLE credit, this class is for 1 hour of general participatory credit. We'll be issuing the participatory MCLE certificate for those of you who have been verified to have attended today. So please be looking out for that in your email later this afternoon. And if you don't see it, please check your spam and junk email. This is also an interactive presentation. You'll have the opportunities to submit questions to our speaker, but we do ask that you utilize the Q&A feature. You can ask questions under your name, or you can ask them anonymously, whichever you prefer. And we will try to get to as many of those questions today. Lastly, you will also receive a link to a survey at the end of the presentation. We really would appreciate any of you who would take a couple minutes to complete the survey and give us some feedback on today's presentation. And with that, I will turn things over to our speaker, Candace Moon.
Thank you, Nicole. So I'm Candace Moon. My firm is the Craft Beer Attorney APC. So I have been working with craft breweries for almost 15 years, based out of San Diego. And they're very interesting clients with interesting issues. So hopefully you'll appreciate what I'm going to talk to you about today. So I'm just going to jump on in. I'm going to kind of go in order of what I end up dealing with. One of the biggest issues in working with, and this is probably with any startup, I'm going to imagine, is helping them select an entity choice and even trying to explain why they need to have an entity. Most of my craft breweries are not very sophisticated, experienced business people. So for a lot of them, this is the first time they've created a company. So trying to understand the differences between an LLC and an S Corp and a regular corporation, trying to get them to include their accountant in the discussion, to help explain sometimes too why they can't listen to just their accountant, because those are just the tax implications. And I really have to explain the legal ramifications as well, so that they understand. They again, just like everything, they have to make a business decision between where one entity might be better from the tax perspective. It might limit some of their legal rights, especially because a lot of these folks are not necessarily going to be the largest investor in their company. So a number of them are going to be doing capital raises, looking for funding, trying to get investors, which is actually one of the things we'll talk about after entity choice. And so there's a lot of hand holding, a lot of explaining, and really just making sure they understand the importance of having an entity, and choosing the one that's right for them. One of the things that I do have to explain to a lot of people is that the regulatory agencies, let's say you get your ABC, that's alcoholic beverage control, so your California alcohol license. And then I'll also reference something called the TTB, which is the Tax and Trade Bureau, which is your federal alcohol license. But those you apply for those licenses either as an individual or as an entity. And if you apply as an individual and then you form an entity, you basically have to do all that licensing over again. Even if you're quote transferring a license, which APC allows you to do, it is virtually the exact same paperwork as getting a new license. And through the years, as I've had more of my clients start to ship out of state, if they are already shipping out of state when they decide to change their entity, that's just more paperwork that has to be done to correct all those licenses and all those other states. More Most of the time, if they're at that point, this isn't converting from a sole prop to an entity as much as I have LLCs converting to corporations. Which one thing to be aware of as because your federal license is tied to the company, the EIN, Employment Identification Number from the IRS. If you convert from an LLC to a corporation, you get a new EIN, and that means you're going to have to re-register with the feds, the TTB, for your license. So, because that license is tied to that EIN number. So it's important to choose it as best as you can from the beginning what entity you want to be. My nightmare scenario was the client who started off as a California LLC, then decided to become a Delaware LLC, and then converted the Delaware LLC to a Delaware corporation. So that was quite a bit of paperwork and wrangling to get that done and done correctly. So entity choice is pretty important. And then following that is, keeping everyone updated with any entity changes, which is what I was just talking about. So a lot of times, they don't see what they had planned at the beginning. They have to shift and change things, or they just don't agree on how things should go. And those changes have to be updated with all the agencies as well. Other entity changes, such as internal changes, people leaving, partners not getting along after a couple of years and dissolving the partnership. They really need a lot of hand holding and discussion about how they want to set up their operating agreement or their shareholders agreement. And I will say that almost all, the startups tend to be LLCs. So we deal with operating agreements more often. And I find that the thing that I love about working with craft breweries is everybody's so nice and so collegial, and everybody wants to get along and do what's best for everyone else, but they don't necessarily think about what could go wrong. And so one of my best stories on this one is inevitably it's either a couple or two friends who decide to get together and start a brewery. And so I had these two guys. One was an award-winning veteran brewer, and his partner had quite a bit of hospitality experience and had an MBA. And so they decided they were going to open a brewery together. And we started talking about ownership percentages and who was going to have what ownership. And they insisted on being 50-50, which I explained that it's rare that both people are 50-50, and what you really want to look at is who's bringing what to the operation and how and basically try to put a number on that and see where you end up. And they continued to insist to be 50-50 until 6 months later, when they were more than halfway through their capital raise. The veteran brewer suddenly thought that perhaps he deserved a little more. And by a little more, he meant a lot more. And he wanted the ownership adjusted to 85-15, which is pretty drastic. And luckily, they worked it out. they continued with the brewery, which, did come together and ended up doing very well. I give a lot of props to the owner who went from 50 to 15, but um, as you can imagine, oftentimes it's not nearly that easy. That's a lot of times where things just fall apart. So they also need a lot of help with operating agreements and thinking about those potential things that can go wrong, and for a lot of people will go wrong, and putting in the contingencies for how they want to operate and handle those situations. So you end up, it's not as simple as just drafting an operating agreement. You have to point out to them, and great fun pointing out to the couple, well, what are you going to do if you get divorced? Who's going to get the business? How's that going to operate? But I tell them that's why they have a lawyer. We're going to bring up the tough situations and kind of force them to anticipate what that might be. I call, as many people do, we call it your business prenup. But that is something that you definitely have to push them on, because they think this is great. We love each other. Nothing will ever happen. This will be wonderful. So definitely need to make sure you're talking them through those operating agreement potential eventually. And then currently, we're seeing a lot more mergers and acquisitions. Ever since COVID hit, a lot of people, well, and again, in every industry, I'm sure, but especially hospitality took some big hits. And although some people, it may not be a financial decision, I think for some people, they're just tired. It was such an exhausting time period of dealing with things that, they're ready to move on, ready to retire, ready to do something else. For some, it's a matter of the cost of the overhead of running the business is just too overwhelming. Rent, equipment, all those things that we're starting to see some companies merge. Obviously, we're seeing a lot sell, but mergers, and I'm definitely seeing more recently an acquisition of brands rather than necessarily an acquisition of the actual brewery itself, which should be interesting to see how that goes. Mainly because I think so many brands are tied to the brewer themselves, and will that brand still have the same legs brewed by someone else, even though it might be the same recipe? So, okay, another big topic, securities laws. So a lot of these businesses don't really understand that there are laws regarding selling ownership in their company. I definitely had one client that this was quite a few years ago, but who just randomly started making his own documents and selling percentages of his company to people. That became extremely messy, as you can imagine, especially because a couple of those people, things kind of went sideways. So there's a lot to be explained. They also seem to think that doesn't necessarily apply if you're selling to your family. But I will say, quite frequently, they do need the money that you can get from selling ownership in your company. And again, you'll hear this a lot today, especially post-COVID, where prior to COVID, I think there were quite a few banks that were excited to get involved in the brewing industry and to lend to people. But obviously, the banks also suffered along with those breweries during COVID. And we're definitely not seeing that money as easy to come by as it once was. So obviously, selling ownership in your company is potentially an easier way to get cash. And I would actually also say, especially with the advent of online securities crowdfunding, or I guess crowdsourcing, technically, the fact that it's just easier to raise money. Well, for some people, I would say, I guess. But we're definitely seeing a lot of that. I have at least 3 clients who have done equity crowdsourcing. And, for some, it's gone very well. For others, not so much. But it is, I will say this, an interesting area, because one thing, and this is true obviously with all securities, but is that there are laws in the alcohol industry called tied house laws, where if you have ownership in one tier, so very quickly you have three tiers. You have manufacturers, you have wholesalers, which are in the middle, obviously, and then you have retailers. And back when Prohibition came about, or I should say at the end of Prohibition, each state basically said that none of those tiers could cross. So if you were a manufacturer, you could not also be a wholesaler or a retailer. You can't be a wholesaler or a retailer. You can't be a retailer or manufacturer, etc. Since then, and the fun of my job, every state is different. There have been a lot of exceptions that have come into play. So in California, for example, as a beer manufacturer, you can also be a beer wholesaler. As a beer manufacturer, you can actually hold some retail licenses. However, in California, you still cannot be a retailer and hold any manufacturing licenses. Where that comes into play here is when you are looking for investors, you need to make sure that these investors are able to invest in your company. And it's a lot easier when you're doing a normal capital raise and the investor questionnaire. I always recommend you put a question in there about any ownership and any alcohol licenses. And that does actually, it's not even just California though. So keep in mind, if they have ownership and an alcohol license in another state, that could still interact with the three-tier system and be an issue. But you need to know if they have any ownership in any of those other tiers, because it could affect your client's ability to have them as an investor. So the real difficulty when doing this online equity crowdsourcing is I don't know that they have investor questionnaires certainly in the same manner. Plus, in the beginning, some of these third-party companies running these processes were not collecting all the information that the alcohol agencies require you to provide of the people that have ownership in your company. So when I'm submitting an alcohol application, and one of the things, and you'll hear me just refer to ABC because that's California and that's who I deal with pretty much on a daily basis. They are going to dig through every entity to get to the people. So let's say your entity does this equity crowdfunding, you get this, long list of people, and then, a handful of entities in there. Well, for every entity, you're going to have to go find out who owns that entity and what percentage they own of it. And if there's more entities that own that entity, again, you're going to have to provide who owns that entity. And if what ABC has done with the names of the people is they bump it up against their database. And if it looks like there are any tied house issues, let's say one of your investors is Joe Smith, and there's a Joe Smith in the database, they have come back to us and asked for information that they don't normally ask on small percentage owners: birth date and last four digits of the social security number, basically just to determine that it's not the same person. Well, unfortunately, some of these online third-party crowdfunding platforms had not collected that information. And it's been a real mess trying to get licensing updated when we have not been able to determine whether or not there is a tied house issue. So that's one thing that I think the platforms are getting better about, is collecting the correct information or the in-depth information needed. But that is a really big piece in the securities area, is just making sure that you are getting investors that are allowed to have ownership in a craft brewery. And I did have one client who came on after they'd already done a capital raise. And interestingly enough, they had originally planned to be a non-alcoholic beverage, and then they decided to switch over, and they had to actually divest about 5 to 10 of the people who had invested because they had ownership in a different tier of the alcohol business. So You really need to be aware of what you're getting into, and as well make sure that, in your shareholder agreement, your operating agreement documents, that, if someone wants to sell their ownership, that again, whoever they sell to has to meet those same regulations. So that's the big speech on securities laws. I will say that, I think a lot of them end up doing the online version because it is probably, well, I guess on the face of it, less expensive than hiring an attorney and doing a private raise. Although my clients that have used these online platforms, I have also highly recommended they work with their own securities attorney as well, just to make sure that they are covered and protected. Although the platforms do offer their securities attorneys, which I find a little odd, but again, it's a very complicated area of law. And again, the majority of the clients here are not extremely sophisticated in business. So you need to be prepared to explain this to them and really help them through understanding why this is important and what they need to do. Okay. Oh, one of my favorites. Entering agreements without counsel. So I will say that the majority of times I see a contract, I'd say 75% of the time, the first time I see the contract is when the client wants to get out of the contract, which, as I'm sure all of you know, is really not the best time. But again, and I'm going to probably say this way too many times, but just like any small business, these guys don't have a lot of money, and the last thing they want to spend their money on is lawyers or insurance or accountants. They want to spend it on bright, shiny tanks and hops and barley, and basically they just want to make beer. But this is also a highly heavy contract industry because you have ingredient contracts, which is funny. When I started, because there was a lot of hop shortages, people started signing hop contracts. No one ever gave me one to review until COVID, when everyone was trying to get out of their hop contract due to the fact that they weren't making the amount of beer that obviously they thought they would be or would have been. There are numerous vendors, CO2, that's a big one. Those are horrible contracts. Music licensing. So ASCAP, BMI, and CSAC, if you're playing music at your brewery, those contracts. Leases, huge. And that's even a tough one because those tend to be more expensive. From the lawyer review standpoint, they're longer. God forbid someone's created their own. It's a lot more to review, but there are definitely some brewery specific issues. Most breweries want to have food trucks. Most breweries want to have dogs. A lot of people do not like the smell of the manufacturing of beer. The smell of the yeast is unpleasant to some people, so you've got to be careful about nuisance clauses. I will tell you that almost all breweries are going to need to puncture the roof, and almost every lease says you can't puncture the roof. So these are just some of the things that, when reviewing a lease for a brewery, you really need to pay attention to. And that is, of course, if the brewery is willing to pay you to review the lease. Definitely seen some that, again, trying to get out of the lease is the first time we see it. Generally, that does not work out very well for the brewery. But what other? Distribution agreements, my favorite. This one's all sorts of fun because again, every state has different laws regarding beer distribution, and what a lot of them have state laws regarding how a termination of a distributor will process and play out. Although sometimes the agreement you get from the distributor from that state does not match the state requirement. So it's very easy to sign an agreement that is actually not correct. A lot of states you are basically locked into an agreement with your distributor and you can't contract out of it. Thankfully, California is not one of those. California is, I think, with the exception of one or two things, the contract rules. So one of the things, and this is from an attorney general decision a number of years ago, is that you cannot terminate a distributor for not meeting unreasonable sales goals. Nice and generic. And then there are some things about if you have a brewery purchase another brewery and how the distribution agreements for the purchased brewery will play out. But for the most part, that contract is going to be how your partnership with that distributor goes. And almost every state, the state laws are pro-distributor, partly because when most of them were written, distributors were small mom and pops working with big breweries. Unfortunately, that has changed, but the laws haven't. Although there's lots of efforts going on and lots of changes being made every year, thank goodness, but it's still very pro-distributor. And so breweries have to be very careful what they sign. There are states where if the contract actually says something that is against the state law, that in and of itself is illegal. So even if a distributor wants to offer certain privileges, oftentimes they can't. Whether or not the brewery knows that depends on if they have the contract reviewed, and if so, who they hired to review it. Because I'm guessing a lot of people don't realize that there are specific beer franchise laws in a lot of the states in the US. So we spend a lot of time putting the biggest thing, the general rule is that you have to have good cause to terminate. I'd say that's the general thing across the country. But the key is defining what is good cause. And a brewery definitely will believe it has good cause, but if it's not good cause in the contract and in writing and clear, then unfortunately it's not necessarily going to work out in their favor. So we do spend a lot of time making sure that good cause is well defined. And granted, as in any contract, whoever has more leverage is going to get to, pretty much have their way on most of the points. So when I have smaller breweries, I'm like, pick one or two things that are really important to you. But when I have the side with the leverage, it's really nice. So we have a laundry list of things that we ask the distributor to commit to doing. That, should they not live up to their end of the bargain, would be found to be good cause to terminate. So distribution clients are huge. I think those are probably the biggest things on contracts. Yeah, leases and distribution agreements, but there's lots and lots of small contracts that they have to sign. And I will tell you, almost all of them won't have you review it first. So, registration and updates. I joke the alphabet soup is real. So there's a number of agencies that breweries, anyone in the alcohol industry has to deal with that are basically, they have the exact same agencies that any business has to deal with, plus ABC, plus TTB. Since most of them should be entities, Secretary of State, Franchise Tax Board. If they're raising money, SEC. Breweries actually have to register with the FDA. They have to let the FDA know they exist. So there are a lot of agencies that they need to register with. And I do know, again, this has now happened twice where we've taken on a client who used another attorney for the purchase. So they purchased another brewery, and that other attorney handled the ABC license transfer, did the purchase, everything, but nobody did anything about a federal alcohol license. So they pretty much had to stop what they were doing. We helped them get their federal alcohol license, but you got to make sure that you hit all the things that need to be done. So, and alcohol, like I said, definitely has some funky ones. But and then of course you have to keep everything updated. So let's say you have an officer leave, you've got to update all the agencies on updating names, updating all the licenses that these have happened. And ABC and TTB both require that you update them within 30 days of the change happening. So that's something to be aware of. Clients, how they forget this, I'm not exactly sure, especially if they're the ones who filled out the forms in the first place. But I will say this, at the end of the day, when you're a brewery owner, there are about 8,000 things you need to do and remember to do. And I would say that paperwork is their least favorite, and therefore the one that falls to the bottom of the list. So we actually, just as part of our firm, and I just started this about a year ago, have a compliance program where we file paperwork for breweries and other alcohol manufacturers. But just because it's something they don't want to do and they don't have the time, and so it's actually something that people pay us to do. So that's definitely a big portion, because it will come to bite you when, let's say, you actually want to sell your brewery or transfer your license and you haven't kept it updated. So we do the paperwork, transfer it, and they're like, wait, who are these people? We don't have this person on the license. And because the license wasn't updated, or the brewery added a suite to their location and never updated ABC. Oh, that's not part of the premises. You can't transfer that. So it comes back to bite you, of course, when you least want it to, but I guess that's true of everything. So intellectual property. This is probably my favorite, because I love trademarks. I find it fascinating. And one of the biggest issues with breweries and intellectual property is I think to some extent they don't start early enough. And I'm not sure that they always know what actually will give them rights. So I will say, I believe there are a number of people out there who think that creating a website gives you the trademark rights to that name, which it doesn't. I'm not sure how many people have much trademark experience, but basically trademark, it's based on sales. You have to actually sell product or sell services under that name. And that's how you can gain trademark rights for that name or logo, or basically whatever you're using as your trademark. So what happens with craft breweries, and again, I'm sure also lots of small mom and pop businesses, they pick a name. Let's say they do a Google search, nobody has the name, great, they start using it. Well, but they don't file for a trademark. They aren't necessarily selling product yet, or they're selling t-shirts because of the brewery that they plan to have one day. But that won't protect the name on beer. It would only protect it potentially on t-shirts. I'm not going to go down that rabbit hole though. Anyway, so they think they have the rights and they don't, or they did a search once and it was clear, so they just keep using it. Or actually they do a search and they don't see the exact same name for the exact same product, so they think they're clear. And just like the rest of the law, trademarks is a very gray area about when something is potentially infringing something else, and how the products cross or are connected. So one thing you need to know is that the trademark office considers all alcohol the same. So if I have a brewery name that I want and there's a winery with the same name, trademark office is going to reject it. They also consider any name on alcohol, any trademark on alcohol is a trademark on alcohol. So if I want to name, let's say I have a beer and I want to name it Ballast Point, that's going to be a problem, because there's a brewery named Ballast Point that has that name on beer product already. You can't have a trademark for beer name. And that's where I think a lot of the issues come from, is the brewery owners just don't know what is going to be considered a problem and what isn't. And it's very easy to think that you've come up with this really creative name that involves the word hop, um, and that no one else would have come up with it, of course. And of course, 20 other people have. So there's a lot of clearance that needs to be done, a lot of just looking out there and looking in the right places. If you don't know where to look, how are you going to know how to find it? And then also understanding that what the trademark office is going to consider a potential block. The trademark office actually blocks a lot of bar and restaurant names for breweries, because a lot of bar and restaurants do private label branding. So that becomes a big issue. And so there's a lot of explanation that needs to go into intellectual property. One of the other areas that's interesting is trade secrets. And I think you run into egos with some brewers who think that even if I told people the recipe, no one else can brew the way I can brew. It won't taste the same. And to some extent, that might be true. I do know that the recipe for Pliny the Elder, one of the most popular California beers, was published in a brewing magazine, and I've yet to see anyone, infringe on Pliny, although I'm sure they've tried. So you don't see a lot of trade secret. You actually don't see a lot of people even trying to keep trade secrets or really concerned about trade secrets. Although I will say, as a brewery owner, you may want to make sure that you do have documents in place, confidentiality agreements, non-disclosure agreements. I have had situations where I had one where I had a brewery, a few of the employees, I think, and at least two of the brewers left, and all three went to another brewery. And that brewery, which was previously a sour focused brewery, started putting out all these IPAs that were oddly very similar to the beers from the brewery they all came from. So there was just a phone call to the owner of the brewery that had the employees just pointing out that oddity. And I don't know that I've ever seen a trade secrets case regarding a recipe. So I do try to focus on ownership of the recipe. So as the brewery owner, if the brewer creates the recipe while working for you, the brewery owner owns that recipe. So, but that's really just more protection. And also, I think once you kind of put it out there, you have less of a chance of those kind of things happening. So a little bit of copyright. There's some breweries that do hire artists to design their labels. Actually, Ballast Point being one of those, at least back in the day. I don't know if they've got the same artist anymore, but they had one artist who did almost, their labels exclusively. Lost Abbey has always had very artistic labels, and so that's a situation where obviously you want to, make sure you own the artwork, and that you get the copyright. And because the other thing too is if it's a very popular beer, you're very much going to want to put it on t-shirts. You're going to want to market that in as many ways as you can and make sure you have the rights to do that from the artist who created the work. Patents I don't see a lot of. There have been a few with like the shape of a bottle, which is a little more interesting, but I'm not going to go into that. Plus, I only want to go another 10 minutes. You guys have time for questions. Employment and labor law. This is probably the hardest area for breweries. Honestly, it's one of the hardest areas of law for me in California. I can't imagine being an employment and labor law attorney because it's hard for me because it's not necessarily logical. And so I think it's hard for employers. They mess up because they're trying to do the right thing. They're trying to make the employee happy, and they don't realize that there are laws about this. You just don't get to make someone's salary because they want to be salary. there's a minimum salary requirement. So you have to potentially pay them more than you would if they were hourly. Um, I had someone who wanted to make all his employees independent contractors, and they wanted that. And I'm like, no, you can't do that. Making sure they know what the current minimum wage is, as it changes frequently. And if they have employees in multiple locations. So let's say you have someone in San Diego, the city of San Diego, but then you've got also employees in LA. Different minimum wages in each location. Safety compliance. This one's a big one for me right now, really trying to make sure they all understand that there are certain things they have to have specific to their location as per California state law. And again, it's not that they don't want to do this, it's that they don't want to spend the money. It's totally understandable. But there's just a lot of things to keep up with. Not only are there a lot of laws, but they change frequently. And then, of course, keeping records and which ones, and consistency of doing that. Say, oh, yes. And then, of course, a couple of years ago, and this is still very true, that a lot of sexual harassment issues. I mean, having alcohol in the mix definitely makes everything a little more dicey, especially because there is a lot of drinking. The state has put in more education and training and requirements, which is great. So it's just a matter of keeping up with all that. But it's a very, very tricky area, and unfortunately much more likely to happen when there is alcohol involved. So we've done a lot of helping out with just putting best practices into place, because obviously a no alcohol regulation is unlikely to go over very well. And actually, I think for some employees is not realistic. So, I mean, my understanding is that as a sales rep for a brewery, you are somewhat the employer doesn't expect them, but it is an industry expectation that sales rep will sample product with the retailers they're trying to sell to. So anyway, it's a tough area and obviously got a lot of attention a couple of years ago. So we are still dealing with all of that. Bankruptcy. Sad to say that a lot of these guys don't end up making it for many reasons. Again, just like any small mom and pop business, you've got people who aren't necessarily business people and may not know how to run a business, so the best thing you can do is kind of help them, at least in my mind, like not lose their home, not lose their personal assets, which is why I'm like, you've got to have an entity. I really, really push that because what can go wrong and to help them come out of that as safely as possible. COVID-19 obviously had a big impact. There were, and what I'm about to talk about is the new models, the new business models that we've seen people pivot to. Contract brewing. So contract brewing is where you hire another brewery to produce your beer for you. And there are actually a number of different license types you can hold depending on how you want to run this business. But I've definitely seen a couple of breweries basically sell off their equipment and their overhead and give up their lease, at least their large facility lease, to do contract brewing. Which again, so someone else's, you give them their recipe, obviously, a lot of documents and contracts are going to go into play here. A contract brewing contract that's definitely going to have confidentiality of your recipe. But basically you pay someone else to make your beer for you, and then you sell it either to retailers or other distributors, etc. Some people just use contract brewing as a way for extra capacity. So maybe they have a smaller facility, and instead of going and building a bigger one, they just contract brew with someone else to help provide them with more liquid. And then The other one, which I'm seeing even more of, because from a licensing standpoint, there are a lot more options and privileges involved, is something called an alternating proprietorship. And this is basically, it's where two or more breweries take turns using the same equipment and the space to produce a product. And so I pretty much describe it as a Venn diagram, because each brewery has to have some exclusive space, but then there's this big space in the middle that they share, which is where the equipment sits. And so you have, one brewery will have the lease for the whole place. That's the host brewer, but the tenant brewer will pay, and they can pay. You can set it up multiple ways. Like, are they paying rent? Are they paying for their time on the brewing equipment, etc. You can basically share ingredients. In reality, technically, you'll have to separate them. So, like, the host brewer could buy a larger amount of ingredients, and then the tenant brewer would buy some of those ingredients from the host brewer. Because you do each have to keep your own records of your brewing, because you are each a brewery with your own brewing licenses, and therefore you pay your own taxes, and have your own product. And what we are seeing, which is definitely a little tricky, and definitely the regulatory agencies also are want to make sure this is done correctly, but is where you have, so you're set up as an alternating proprietorship. So you have your own brewing license, but you then hire the host brewer to do the brewing, which means you have the brewer's license, but you're not actually in there doing the brewing itself. But again, it's your license, you have your own records, you pay your own taxes, and you've got to keep those things very separate and keep those records for both the state and the feds. That's becoming very, very popular, mainly because the privileges you get of having a brewing license in California are a lot more extensive than the privileges you get, let's say, with a wholesaler license, which is another license you could get to basically have someone contract brew your beer. Having your own license, so in an alternating proprietorship, you could actually open a standalone tasting room. So I could have an alt prop with this other brewery where I'm sharing equipment, sharing lease, but then I can open another location that can serve just as a tasting room. So one other thing to note is that in an alternating proprietorship, the two breweries cannot share a tasting room. That tasting room belongs to the host brewer, and the tenant brewer cannot participate in that tasting room, but they can open their own on another location by virtue of having a type 23. They can self-distribute, they can sell directly to consumers. There are a lot of privileges that go with being a beer manufacturer, which is what is driving people to have that set up, to get that license and to operate that way, as well as the fact that you don't have to put a ton of money into a bunch of overhead. And you don't necessarily need to have a bunch of investors. But that said, once you start and your beer gets out there, your brand is in the market, and you start seeing some success, that in and of itself gives you a lot of leverage to then perhaps bring on investors. So there's a proof of concept that is a good way to get a start in the brewing industry, I think a lot of us would say. So my last slide is just heads up, brewers are incessant do-it-yourselfers. They would love to do everything themselves. I've had clients write their own contracts. It was very frightening. But they will do it, and you do have to kind of temper them a little bit. I will say, and this is also just as, I have my own law firm. I do a lot of payment plans because it is definitely tough for them to have large sums of money up front. But I also do a lot of flat fees. I think that when you're dealing with, and again, true, maybe any small business, I think a lot of people are afraid of the hourly rate. They're afraid of what bill's going to show up. And I found that flat fees work a lot better, or even caps, so I don't know exactly how much it'll be, but it won't be more than X. Again, they don't want to pay their money to you anyway. They don't want to pay it to anyone. But their vendors, like I said, tanks and ingredients, they just want to brew beer. Um, but just be aware that that's pretty much how they operate. At the same time, much to they're really good clients, but they also won't necessarily tell you what's gone wrong until it's a little too late. So back to the bankruptcy topic, I had one client who I heard from them 2 days after they got the 3-day notice on their door to vacate because they hadn't paid rent in 3 months, rather than letting us know ahead of time, hey, by the way, we've gotten to a point where we can't pay our rent. What should we do? And unfortunately, they were at a point where it was just too far gone and there wasn't a lot that could be done for them. But again, they want to do it all. They think they can do it all. And so they can get themselves in trouble. But that was my last slide. And so if there are any questions.
Okay, so let's see. Someone asked, how common are alternating proprietorships? Like now with the new trend, are you seeing this more?
They're very common now. They're becoming a lot more common. I mean, people have done them for a long time. I mean, one of my first clients was an alt prop. That was 15 years ago, but they are becoming much, much more common as the industry has tightened up a bit.
And then another person asked if they could see the alphabet soup slide again. I think that was the one with the
Yeah.
different agencies. And if you could briefly go over updating with these agencies again.
Basically, when the brewery first opens, they have to submit paperwork to all these agencies. So like when you create an entity, you file it with the Secretary of State. And the state, once a year, you file a statement of information. But you're supposed to file that if something changes before your deadline, you're supposed to file it. Like if an officer changes or the mailing address changes or any of that. Same with anything that was on your ABC application, anything that was on your TTB application. The IRS, let's say the person who was your initial contact for the EIN number when you apply for that with the IRS and they leave the company, you need to update that contact with the IRS. Basically, it's just a reminder of keeping all the regulatory agencies updated when people change. It's usually people more than anything, like someone leaves.
Very interesting. Someone asked, what is usually the business structure for these? Are they LLCs, partnerships, S corps?
Most of them are LLCs. I have a couple who are S corps, although the S corp I think legally has some more limitations, which is why I don't have as many of them. And I only know of one brewery ever that was a partnership, and they weren't one of my clients. So I think the LLCs are more flexible, and because these people may not be the ones putting in the most money at any point in time, it's a good structure for them, at least in the beginning.
Okay. Somebody asked, is it better to do a sublease in a shared proprietorship with host as the tenant? With the host
Oh,
as the
okay.
tenant.
So generally, you're not going to have a sublease in an alternate proprietorship. Those terms are going to be included in your alternate proprietorship agreement rather than a true sublease, which is good because generally your lease is going to require you get your landlord's permission to do a sublease anyway. The only situation where I have it flip is if the host brewer doesn't care about the tasting room. So let's say the brewery that's already there doesn't use their tasting room. They're just doing production and sending it to distributors. Yes, I think what you could do is the host could do a sublease, which would include the tasting room, and the tenant brewer could have that sublease. There's a way to manipulate it. It's a little complicated. And sometimes I sometimes have to write it down to think it through, but there are ways that the tenant could actually be the host. You just have to kind of flip things a little bit.
Very
I don't know.
interesting.
Whoever asked that question, feel free to email me.
That
It
one
might
wasn't.
be easier to answer one-on-one than in a presentation.
And then I think this will be our last question, but somebody asked, any thoughts on recent non-alcohol trend in brewing?
Oh, yes. First of all, I'm a huge fan of NA beer. And it's interesting because even as an NA beer, you still need a TTB license. But you don't need a state alcohol license. So, but it has to do with beverages that have malt, even if they're less than 0.5% alcohol. But it's interesting. It's very interesting. I think it's a great trend. I think for multiple reasons. One, personally, I'm getting older. It's healthier. I can't drink as much beer as I used to, and I like to drive home. So it's nice to have non-alcoholic options I can switch to. But I also think for the business, it's great because it's something else a brewery can offer, and it gives them more offerings to customers coming in. So it's weird. It's kind of, there are a lot of things that it will kind of fall in the world of a lot of what I do, but yet there's a big chunk that it doesn't fall into. So
Well, with that, I just want to say thank you so much to our speaker, Candace Moon, for such an interesting MCLE presentation. I also wanted to thank the participants for attending today, and I just wanted to remind everyone that you will receive a link to a survey at the end of this presentation, and just reiterate that we would greatly appreciate any of you who took the time to answer that survey. Thank you again, Candace, and thank you everyone for attending.
thank you for having me.
Bye, everyone.